executive order says we're supposed to try to get it live if possible. So,
Yeah.
so as long as
So-
one of those is live, we're good.
Exactly. YouTube will be live, and then we have a recording of this too.
Perfect.
And Robert says you can go.
Robert says we can go. Okay. So we will proceed on. I will call this meeting to order. Let's do, the first thing we'll do is we'll run through the verbal attendance. And I've already documented that everybody's here. So Roger Lindsay's present. Tom Jones.
Present.
Susan Besser.
Present.
Al Cox. Albert. Al just walked away from his chair. Michael Harbauer.
Present.
Ann Peterson.
Won't let me, I'm sorry,
Oh,
present.
you're
It
good.
won't let me
Okay.
just push my space bar.
Okay, Ann's here. Michael Scott.
Present.
And Al Cox, you're present now?
Present.
Okay, we're all present. The first item that we have to, the housekeeping issue is consideration of resolution 2020-213, a resolution declaring that the Stormwater Appeals Board members shall meet on October 20th of 2020 at 5:30 p.m. and conduct its essential business by electronic means rather than being required to gather a quorum of the members physically present in the same location, because it is necessary to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak. Do I have a motion for approval of that resolution?
I'll move to approve. Second.
Okay, yeah, whenever you make a motion or a second, give me your name as well. So who made the motion?
Albert Cox.
Albert, okay. And who made the second?
Michael Harbauer.
We have a motion and a second. By roll call vote, the chair votes aye. Tom Jones,
Aye.
Susan Besser,
Aye.
Al Cox,
Aye.
Michael Harbauer,
Aye.
Ann Peterson,
Aye.
and Michael Scott.
Aye.
Okay, so that motion carries. Now, the next item on the agenda is the approval of the minutes from our September the 15th, 2020 meeting. And so we talked about that a little earlier before we came online. Amber had gotten copies of her transcript. It's a lengthy transcript. Has everyone had a chance to look at that transcript?
I have. I've read it.
Do we have a motion to approve that? That transcript represents the minutes of our meeting. So does anyone, do we have a motion for approval?
I move for approval. Ann Peterson.
Okay, Ann, motion for approval. Is there a second?
I second Tom Jones.
Okay, by roll call, chairman votes aye. Tom Jones,
Aye.
Susan Besser,
Aye.
Al Cox,
Aye.
Michael Harbauer,
Aye.
Ann Peterson,
Aye.
and Michael Scott.
Aye.
Okay, thank you. The next item on the agenda is a request to appeal the city engineer's decision by Alex Chan for the property located at 1228 Lakeview Drive, Franklin, Tennessee 37067, specifically for relief of $19,000 of civil penalties resulting from failure to meet construction deadlines associated with drainage improvements required by the city engineer to relieve downstream flooding at 1226 Lakeview Drive, Franklin, Tennessee 37067. I'll turn it over to staff. Jeff?
Okay. Good evening. So we're here to discuss the appeal of the city engineer's decision. This was deferred last week or last month, excuse me, on a September 15th meeting. it was asked by the board for the city engineer and staff to revisit the determination of the civil penalty of $19,000. So I'm happy to go through any part of the staff report again. It is very lengthy. Nothing has changed except for page 10 on the PDF. The last two paragraphs of the background state that the appeals board have met and we locked in on a 3-3 vote on the matter, and then ultimately it was deferred to this meeting, October 20th meeting, and in the deferral, the board asked on city staff to review the decision associated with the $19,000 worth of civil penalties. So after the reevaluation of the decision by the city engineer has determined that the issuance of the $19,000 civil penalties is justified. We went back, we looked at all of those things in the ordinance under section 23-111 that it states that the city engineer should look at to determine the amount. We went back through all of those. I'm happy to share my screen in that section of the ordinance if we would like to look at that. But basically we went through it and, we focused in on those again. And we looked at one of the items was the degree and extent of the harm to natural resources, to the public health, or to public or private property resulting from the violation. We went back in, we looked at the amounts that the Lakeview Condo Association had spent on remediation of the issue. It was $30,000 approximately of engineer design fees, and most of it came in the form of the work that had to be done. They had to hire a water abatement company to come in and treat for mold, and they had to replace the first 2 feet of drywall in all of the apartments. And I want everyone to also know we're not talking about residences. We're talking these were all condos that were being rented out for businesses. So it's a condo association, but it's really a business, a business complex down there in that bottom. They had told us that they lost work. The businesses all had to shut down and get together to come in and take care of the issues, to try to remediate all the damage. So they had loss of time and money associated with the businesses being ran. We tried to look at all of that, and they couldn't put a price on that for us. So, we have the $30,000 of, hey, we know we spent right around $30,000 abating this, but, it didn't factor in all of the loss of their business operations, the time and effort that were associated with that. It's real hard to put a dollar amount on that, but I would say that that's every bit of equal to what they spend in actual money that they lost in business operations. So we tried to look at that. We reevaluated that. We tried to look and reassess. How long did it take us to get compliance, and was this an adequate normal amount of time, or was it reasonable? And we felt what we asked was very reasonable. We gave 4 extensions in the matter. So we looked at the duration and gravity of the violation. The condo association had told me, Mr. Wilson, that they've been working for years. He said that it was 6 or 7 years that they'd been dealing with this issue. That's a long time. We're not talking, days or months. We're talking years that they have been dealing with the issue. And then finally we looked at, the staff time that staff has the cost of enforcement to the city is what it states in the ordinance. And we went through, went back and revisited, the hourly rates of the employees, including benefits, that everyone spent on the project. I, of course, have had the most time. I've had several weeks of time over the last 2 years in dealing with this, and just that amount alone come to $14,800. So I think when you look at all of that cost together, I think $60,000, is what we kind of thought was a number, considering all of those different sections of the ordinance that it tells us different things to look at. So, the city engineer, I spoke with Mr. Holzen, and we felt that the fine was still justified. However, the Lakeview Condo Association and Mr. Wilson had, they were just happy it was done. And, they personally told me that, they didn't wish any more fines or penalties to be imposed on Mr. Chan. They were just happy they got a product and it's finally done. And they wish they hadn't had to gone through all of that and spend all of that money. But at this point, they were just ready to be done with it, I think. So I think that ultimately the city engineer and I sat down and we said, okay, well, we'll break this down to what does it cost the city at this point. We're willing to, the condo association, doesn't wish, the fine imposed anymore, and they're happy with everything. So, let's take away everything but just the cost associated to the city. And we come up with $14,800 of staff time and said, we think that at least should be recouped to the city for the cost of dealing with this issue. This issue should have been handled through a private. The city never should have had to get involved in this. That's at least our opinion of the matter, is that this should have been worked out between property owners. But we had to get involved. This wasn't something that was an obligation of the city to perform. So we offered that amount to the Assistant City Administrator, Vernon Girth, and he reached out to Mr. Chan on October 6th. Mr. Girth told me that Mr. Chan requested to have some time to think about it. And I never received anything, nor did he, as to date, regarding Mr. Chan's response to the offer of the staff time associated with the matter. So that's pretty much the summary of the staff report at this point.
Okay.
There's not really any other new information besides we went in and just double checked and looked at all of our figures again in determining if the city really was justified in that $1,000 a day civil penalty. And I know that a lot of people are hung up on, well, we've got a project that only costs $20,000, but we've got $19,000 worth of civil penalties. That doesn't seem fair. And I do understand how one might look at that, but the two really are irrelevant. The project could have cost $5,000 and the civil penalties could have been $100,000 or vice versa. The civil penalties were imposed due to a lack of meeting a timeline. We weren't, the cost of what the project was going to cost to put in was irrelevant to our determination of that amount, because we were looking for compliance. And we were using civil penalties to achieve that compliance. And so I don't know if I did a good job of explaining that in the last meeting. So I want to try to clear up, how we looked at that. We weren't looking at the cost of the project. We were simply looking at compliance, and compliance could have gone on, non-compliance could have gone on for another weeks or months. It could have been a $50,000 fine, or, if Mr. Chan had responded in 2 days, it would have been a $2,000 fine. So the civil penalty came due to lack of compliance and days beyond timelines. And that was irrelevant to the cost of the total project. So I just wanted to take a moment to try to touch on that a little bit. And that concludes pretty much
Okay.
what I had to say regarding the staff report. And I'm happy to answer any more questions, but at this time, the city engineer's determination was that he was justified in the issuance of the civil penalties.
Okay, thank you, Jeff. Is there anyone from the public that would like to speak to this issue today? I see Alderman Berger has joined us. Valerie, do you have anything that you wanted to offer today?
I'm sorry, I was unable to get on at the very beginning. I was planning on being here at 5:30. I missed some of this, but I've got the gist of it. I mean, I've been dealing with this for years and years and years because I was contacted years ago about issues. I guess another question, like the cart before the horse question to me, is when the gentleman who built the building at the top of the hill built it and built the parking lot without approval from the city of Franklin, and thus in essence caused a lot of these problems to happen. I sometimes find that we've got the cart before the horse in this situation because this gentleman, Mr. Chan, has been dealing with an issue that originally was caused, if I'm not mistaken, from over the years of being told, over the years and years, was told, by city that this parking lot has been the crux of the matter all along. And so I don't quite understand how we even got to this point, and the parking lot that was built without approval, why that person never corrected the problems in the beginning. Thus, Mr. Chan had these other problems associated from those problems, and then it exacerbated into what it is today. So can anybody explain that to me and why we are where we are today with this? That to me, I don't think that was ever remedied. Was that man ever charged fines? I don't know. I'm just confused about this because I dealt with the city for a number of years with it, and it just seemed that was never remedied.
And Jeff, if it's all right with you, I'll take a shot at answering this question. I will say that that Mr. Brazel, and I don't want to confuse these issues, but I'll try to give you a summary the best I can. Mr. Brazel did add some parking that is just uphill of Mr. Chan's property. He did so without permits. He did so without planning commission approval and meeting proper zoning. With or without that parking lot, these problems would have occurred, because the problem is on Mr. Chan's lot, the way the drainage was being directed was all directed to the downstream property, causing these problems. Now, did it make it worse? Obviously, the more impervious surface you add, the bigger the stormwater runoff, the bigger the problem that you have. But it's my opinion, with or without that lot, these issues would have still continued. And if the solution had been to simply go after Mr. Brazel for the illegal parking lot, I assure you that staff would have done so. And looking at this again, it was a two-pronged approach. Both had to be corrected. One, the drainage on Mr. Chan's property had to be directed away from the downstream property owner because they were clearly flooding them out. And the pictures speak for themselves if you look at the damage. The other issue upstream, while the impervious surface certainly added a little bit, would not have solved this problem. The flooding still would have occurred downstream. And so we are also pursuing action against Mr. Brazel, and Jeff could speak on the progress we're making there. But they are two separate issues. And I assure you that with or without the addition of that parking lot, this problem would have still occurred. The damage would have still occurred. And I can only speak from the time in which we got involved to try to get it corrected. I don't know what changed, if it got worse or whether it finally started penetrating the building. I can't speak to that, but the amount of water that was being directed would have resulted in the same end scenario with or without Mr. Brazel's property. Additional parking lot. I hope that answers your question.
So, thank you, Paul. So, did the parking lot issue with Mr. Brazel exacerbate the issue and cause greater damage?
I'd say no. I'd say it would have happened either way, to be totally honest with you. I mean, it was a small impervious parking lot that he built up there. There was still a large amount of surface water being directed at these buildings. Again, my professional opinion is that it would have resulted in damage downstream with or without Mr. Brazel's issue with adding that parking lot. Well, obviously increase impervious will increase the amount of water that goes there. Was also being targeted for zoning violations and not getting approval through our planning commission and meeting our development regulations.
Okay, and Mr. Brazel's parking lot, that issue is older than this issue. So we're dealing with this issue right now. Is his issue, Mr. Brazel's issue with the parking lot, has he up to this date ever been fined by the city or taken to task for not getting that permit? Or I know you said you're dealing with him, but I just wondered what the history was. That has he been fined or been brought for the city for his part in that parking lot? Because I actually, was told by the city, I think this was a while back, Paul, probably before we talked a long time ago. I think when David was here, that, there was, causing a lot more water runoff. The volume was increased. But anyway, I just want to know if, has that been taken care of yet, or is that still?
Alderman Berger, I think we're getting a little far afield of
we are.
of the substance of this
Okay.
meeting today. This was discussed extensively at our last meeting, and so I'd like to keep us on track.
I'll hold that for another time. But
in general, a property owner is responsible for accommodating the water that comes on his property, and he's responsible for controlling it as it comes across his property. And the effect of this was incredible damage to his neighbor downstream. And so that's what we're dealing with here.
Okay, thanks.
Okay, so I'd like to turn it over at this point to Mr. Chan. Do you have anything else that you'd like to offer at this point today?
Yes. So first of all, thanks for everybody for being here. And to respond to the first thing that just came up just now, talking about the property, where Paul was talking about how this issue could have been, or in his opinion, was already there even before Dan put his illegal pavement. Well, we never got, when I first bought the property at 2012, we never had any complaints. It was only until later at about 2015 was when I started hearing from Lonnie. Lonnie started coming in and telling me that, hey, we need to get something done. And so I don't know, at that time, the parking was just put in, the illegal pavement. So as to Paul's point, I don't know actually what caused this problem to suddenly increase that much. But what I will tell you is that at one point, I bought the property from Dan. So Dan owned the whole thing over there. So he was the one who would have developed this whole thing and would have then had the option or opportunity to fix this during the time when he had submitted his permits for subdivision. But okay, so now let's determine that that's passed. So now it's determined that it is my responsibility as the property owner that I have to deal with the problems as they come. Okay, and that's fine. I was ready to do that. So we talked about this whole thing in our last meeting. We were saying that the city needs to be fair, needs to be firm, friendly. Okay, I just find that the biggest problem with this whole thing is unfair to me. So why is it unfair? Let's go to firstly to the offer that I got for this 14,800. 14,800, the reason I thought a long time for it, I was thinking that, hey, that's something, right? That's a few $1,000s less than the 19,000 that I was being charged. Well, the problem was that when I asked Mr. Gurv why this, how did this number come about, as explained just now by Jeff? Well, the big part at that time, Mr. Gurv just told me that it was the engineer's cost to do the work that they put in, the staff that they put in. Well, really, aside from the phone calls and emails that had happened, the biggest work was done actually by Paul when he actually came up with a different design that he stated that this would be, hey, go and bid this. Okay, that was the last design that I got from it. And I appreciate that, Paul. I really appreciate that. But is that $14,800 worth? Is that $10,000 worth? I mean, I got my engineer to do the work for $3,000. Okay, yes, we did not use his plan, but that plan was the jumping board for what you had done also. So that's one thing. The next thing is that Lonnie had actually told me twice, okay, that he had actually went to bat for me twice of this whole issue to try to get my penalties either dismissed or reduced. And, you know, all of you have already heard that during the last meeting that we have, one of the letters, but he actually submitted two. So he had already gone to bat twice. Now, why is that the case? If Lonnie knew all this time that it was my property, well, simply is because he knew that I was always helping. He told me, in fact, on his communication, he texted me and said, look, he just submitted a letter again. And the reason why was because he knew that all this time I was there to do the work. I was there to try to mitigate this. What you saw there before the drains were actually put in, this new drain that was put in, was actually work that we had tried to do to mitigate this problem. Well, and he saw that, he understood that. So we did try. So how can it be that, you know, that now the victim himself is actually coming to bat for me twice? You know, how is it fair that I get $14,800 as a reduction? Well, as the final penalty. Okay, so that's why I could not come to accept that, the $14,800. So now go back to the original penalty. All right, so the original penalty, why do I feel like it's not fair? I'll just summarize these points here. The first one is back in May 2019, I was ready to go at this. So we talked about just now, Jeff talked about non-compliant. Well, I was compliant. We met a few times before that. And I was all this time, I knew by that time that I was not going to get away from this job. I was going to have to do this. So because I owned the property. So I was ready to go on May 2019, but when I was told to stop. Now, the city said that I should stop and wait for Dan's plans to get approved. But, you know, during our meetings, it was already clear that Dan was not cooperative. Then what happened was Lonnie's property got flooded during the end of November. And then I was suddenly rushed. I got an email saying that I had to appear, and then I was rushed to get job bid in 2 weeks. Okay, so the time at that time, that's December. That we all know in construction, that is the worst time to try to get any work started or even bid out. If the work is already in progress, that's one thing, but this is starting to get bids. So how could I have done that that quickly? Now, so how can that be fair, right? So then now the thing is, we have the next thing is Dan's illegal payment. All right, we have all these years that Dan never cooperated. We cooperated. We done 2 separate works. You know, we talked about private properties doing this themselves. Well, we did. We actually tried to do it. We did what we could, and we couldn't get it done because one of the problems was that we had to try to divert the water into the I-65 or whatever, and we could not get it done, at least not to our capacity, because it would have been exorbitant and price-wise. But again, the problem actually increased in intensity for Lonnie. It wasn't something that just happened immediately. It slowly increased until this last November, where he really got flooded. So the city says that, hey, you know, I was given 4 extensions. Well, had I been more cunning like Dan, okay, who has not been penalized near the magnitude of my 19,000, right? Had I been more cunning, I would have just asked for 1 extension till the end of February, right? Had I been smart enough, maybe. I would have asked for 1 extension. Then the city would not have said that I asked for 4 extensions and gave me that 4 extension. So, but I did not. What I did was when the city told me that, hey, look, they just got flooded, we need to hurry up on this. I did what I could. I tried. I did what I could to get it done as quickly as possible, to the point where I was foolish enough to agree on whatever timeline that was set on me. 2 weeks to get a bid out. Here, another 1 week to get this. Oh, you couldn't find somebody? Here's another one. Okay, try to get this. Finally, I did find somebody, right? So is that fair? That cannot be fair, right? I mean, for me, just because I was trying. So then the next point. The city says that Dan's work is actually more complicated, right? He was given several months to do to submit his plans while I was on hold. Well, did you all know that he was actually trying to sell his property at the time? He actively listed it up. And the reason why I know is because his real estate agent came to me and asked me if I wanted to bundle my property with his so that they can all get a better price, right? So he was actually trying to do that. Now, the engineer that Dan was using to draw his plans was also my engineer, the engineer that I hired. And what he told me that Dan's plans was actually ready to be submitted on June 3rd last year. So I was put on hold in May, but his plans was already ready in June. So what was that delay? He was deliberately delaying this whole thing. He was trying to hold out so that he can possibly get it sold. And then he don't have to do this whole thing. Because why? I asked the property and the real estate agent. I said, did you know that the city actually is obligating him to do work? He said, no idea at all. This was all news to him. So he was trying to get out of this. And yet here I was waiting. And what happened was that the city basically was fooled, right? You guys were fooled. And then finally, when Lonnie got his big flood, and then suddenly, the hammer came down. And who did it come down on? It didn't come down on him because he still has not submitted his plans, or he's still working on it, I guess he claims. But it falls down on me to have to do this. So how can that be, again, fair, right? Here's another detail that was skimmed in the summary that the city had, okay? So they say that this detail was basically is like this. A big amount of that fines was actually put on me because I could not start the work. I managed to finally get the contract in, but I couldn't start the work. That was a big hunk of the fines. Well, the reason why was because Mike Moody, who was the one that I finally got a contract with, okay, he was the only one out of several that I've looked. And he is actually one that the city has regarded well recommended and regarded to be a good one. Well, he contracted pneumonia. And again, this is in the start of this whole COVID thing. Well, he got contracted pneumonia, went into the emergency room at Vanderbilt. 70 years old, that man, right? I mean, he's more than 70. He looks frail. Well, he told me that, look, he cannot do anything. We had to wait. Paul was nice enough to wait. All of us waited. But the clock was still ticking on me. Whether if the money was already, the fine was still racking up or the pressure was racking up, either way, it is still ticking on me, right? Well, I had to wait for him to finally get well. When he got well, he also had to then develop a plan because his condition of taking this job was that he had to do it his way. He didn't want to do it the way that Paul had given me, the plans that he had nicely drawn for me for $14,800 accordingly. Okay, so this plan that he had given, Mike said, no, can't do it. The condition was he's going to do it himself, but he needed time to draw it out and get it to Paul to have it approved. He couldn't get it to Paul to approve until he was well enough to even come out to meet with him. There was a lot of back and forth. When should we meet? He finally came out and meet. He couldn't stay he had to stay on his truck, come out and all that. I mean, it was a pain, but we finally got the work started. All right, on March 11th was when we got started, and it was a perfect solution, right? Everybody admits now that it is great. But why is it fair to penalize me for that, right? For the gentleman getting sick, and it was gravely a grave sickness too, right? And yet I'm being penalized for it. And why? So really, basically, I would say that you cannot call me non-compliant. You just cannot say that I'm non-compliant, that I've not been trying. I have. In fact, I should have not. I should have actually done what Dan does. Maybe I will grow up one day and learn to do that. and say that, hey, no, I'm going to delay my way all the way until one extension. I'm going to not ask for more extensions and really try. So Lonnie, based on what Lonnie had told me, everything we've learned, the conclusion is this. The city is basically, had the city not been at fault in falling for Dan's deliberate delaying, I would have done the work in May. Okay, probably easily find a contractor, would have done the work. We would maybe have to redraw the plans, but the city would not have been pressured. Why? Because Lonnie would not have been flooded and caused that, however much money just now Jeff was telling me, $30,000 or whatever, okay, of damages in November, had the city not fall for Dan's delays, which those delays was not new. It has actually been much longer than that, right? So with that, how can it be that I am now punished for that? I mean, anyone in this meeting, as well as outside of this meeting, anyone, if we were to bring this case as it is right now, will agree that it is just not fair that I get punished like that. How can it be called that I'm non-compliant, right? I did my part. So I really hope that we can do something about this, and I trust that you guys will think of my shoes, because 19,000 or 14,800 is just a lot of money, especially for me where my projects have stopped because of what's going on right now in the world. Okay, so this is not easy for me, and I don't know how I'm going to do this. Especially now, my tenant over there is also asking me for rent credit. Why? Because he says that, hey, he's a car dealership, right? His parking is all out of commission. There's no way that he can park his cars there to sell. So you talk about disruption. Well, he has disruptions too. Now his disruption, I'm willing to give him credit for my work. But he is also now claiming that, say, hey, look, Dan's work is also causing him problems because of all the big machineries there. Now, I'm still trying to negotiate with him, but that's extra problems with me and him and extra financial burden on me. So this $19,000 fine plus the $21,000 when you add all the engineering costs and construction costs that I've already paid, plus whatever credit that I'm now having to give to my tenant over there to keep him happy, is a lot of money. I mean, that's ridiculous, I would feel, for what's going on. And I'm sure there'll be a lot of people that would agree with this. So I hope you guys will do the right thing here, please.
Okay, thank you, Mr. Chan. So to the Stormwater Appeals Board, then, is there a motion for this item?
Mr.
Yes.
Chairman, can I ask a couple questions first?
Sure, Tom. Tom, we normally need a motion with a second before we open discussion on the item.
I think the item's already in front of us. I think it's open for, I think we have under the rules and so forth under the Stormwater Management Board, I think we have the right to ask questions before a motion is put there. If you take a look at the sections. Because I'm not sure what exactly, until we get some discussion here, I mean, what kind of.
I know it always seems easier that way. Counselor, is Mr. Squires, is there a clarification on the need for a motion prior to discussion?
Sure. If you have, once you've had a presentation by staff or an applicant, if you have factual questions for them, I think it's fine for you to go ahead and ask those. The motion needs to be on the floor before you deliberate, before you discuss the action you're going to take. If you need clarification on some information you were just asked, I think it's fine to ask that.
Okay. All right. Proceed on then, Mr. Jones.
Okay. My first question is to Jeff. I guess you're the only one. Are you the only one here for the city now? We don't have the city engineer here, do we?
Yeah, he's here. Paul.
I'm here.
Paul's
Yes,
here.
sir. I'm here. Jeff did take the lead on most of all this, but I'm happy to.
Okay. Tell me, here's a question I've got is I'm trying to figure out, was there, and I might just miss this, is Mr. Chan, what construction, I'm taking this as coming back because of construction that he did, because I'm trying to figure out first is how we're really even involved in this thing under the wastewater management under our section here. Was he making construction that started this originally?
It was the flooding that was caused. And legal counsel might clarify this, but we commonly get drainage complaints from residents where they're receiving flooding and runoff from an upstream neighbor, and we will get involved in those when it becomes a significant issue as causing structural damage or something to that effect. And there was a portion of Mr. Chan's parking lot that was put in unbeknownst to staff like Mr. Brazel's. It was a lot smaller portion, and it was determined that part of that was contributing as well. So we felt that Mr. Chan and Mr. Brazel had done things, and I know Mr. Chan has disagreed with staff a little bit on who did that, and we aren't sure. We can't say if Mr. Brazel did it or Mr. Chan did it, but that is what started the process of getting the city involved at that point, and so that's when we stepped in, and you can't do anything that aggravates downstream flooding to your neighbors.
Okay, I'm trying to say, I guess what I'm looking at it first is one, is this a city matter or this should this not? I mean, as far as the condo, the association and so forth, from reading our statutes and so forth and our guidelines here, they've got remedies in a court of law for their damages and everything. Is that's not a city under stormwater management. That's not really. I don't think it's really a responsibility of the city to be involved in that part of it. Is they've got the court system that they, I'm amazed that nobody's talked about I don't understand why there wasn't a lawsuit filed by the association to collect their damages here and still the city being involved in this. Because under this management statute, I'm trying to see where, if this gentleman here started construction, because that's where under stormwater management, I'm trying to see where we have where you really have jurisdiction under this, under section 23, title 23.
Again, the direction that I've always been given on that is that it governs all properties within the corporate limits of the city of Franklin, and I am not a ordinance or legal expert. And, I do my best on the interpretation, but I believe that, at least from the city standpoint, that we had every right to get involved in the matter, as it was affecting a residence. It was definitely affecting private property as a result of some of the paving. So
that's what I'm asking. So you say, that's what I'm trying to see is what he did after he took possession of property. Because under section 23-102 in jurisdiction, it talks about exemptions. And one of them is under section 23-102, section 2, subsection B. It talks about has to involve was there greater than 10,000 square feet or new work, or if there's improvements of involving less than 5,000 square feet. If it is, under this section, it's exempt.
sure. So
That may be something you'll hit your legal counsel about, but
I just add to what Jess stated was another reason we thought it was appropriate was on Mr. Chan's property. There was some pavement also added, a very small amount, but there was some pavement added without approvals that weren't reflected on the approved site plan as another reason that brought this into what we consider to be under Title 23 as far as making sure that they're not aggravating. And I can't tell you what changed. These properties are pretty old, right? What changed over all these years to suddenly created this problem? I don't know if there was a berm removed, whether Brazel did it or whether Mr. Chan did it. I have no knowledge of that, but something happened over the course of time that started creating all these foundation problems, where all the water was directed to the building. And I can't speak to how or why, but I do know that there was some pavement added on Mr. Chan's property as well that's not reflected on the approved site plan.
What do you say? Was that?
I will clarify that I did not approve of any pavement, and I did not pay for any pavement. So I would I'm sure that this was done actually before I purchased it. Again, this was all owned by Mr. Brazel. And before I purchased it, there was already a car dealership, my previous tenant, that was already renting this about 1 year prior to me purchasing it. And when he bought it, well, when he was renting it, I think that was when the back pavement was done. But that back pavement is surrounded by pervious grass. So I don't know, again, I don't really think that would be the case if it was studied. But just so you know, I did not approve of any of that. I did not, it was not sanctioned by me.
Tom, did you have anything else?
I guess I'm just still trying to figure out. I'm trying to see where the city, and I'm not saying it's not under another they don't have it under some other area, but I'm trying to figure out exactly how we come into play because of if there's storm water running, causing city damage, and by something that this gentleman created. I guess that's what I'm trying to, because that's a lot of money to be finding this gentleman for something if he didn't create it, And like I said, now I think he's got I think the condo association has a potential lawsuit. I don't understand why they didn't have a lawsuit they filed, against both these parties on the water runoff. I guess I'm just trying to decide how we're really involved in this. And that's what I'm trying to get the city. Other than that, I know they're trying to be helpful to a citizen, but I'm trying to see where there's no stream, we don't have any damage. There's no streams involved in this, or there's no water quality damages, or at least that's what I'm trying to look at and see what, normally under our jurisdiction, and we're talking about where there's, flooding, as far as quality of water, creeks and so forth like that, that there's potential damage to. Grading, I'm saying, did he do some grading? Was it? What I guess I'm trying to see is what construction did he do once he took over the property that caused that it exacerbate this flooding situation?
Amber, can you make my screen shareable, please? Here's the paving that was in the original notice of violation.
Okay.
And we weren't there when it was done. But we have aerials. And so we tried to go back through our aerials and determine when it was done. And in 2012, which is when Mr. Chan took over the property, and it was the most recent aerial. Sometime after 2012, this was done.
Okay.
And so, we don't know, but it was the current property owner's responsibility at that point. Whether Mr. Chan did it or Mr. Brazel did it, I don't think we can say for certain. We just know that it was done sometime 2012 or afterwards. So that is where what we used and put in the original notice of violation. And you can see right up to the north, the section that we find Mr. Brazel for as well, or we wrote the notice of violation for. And yes, Mr. Chan's portion was a smaller portion, but ultimately, as Mr. Holzen said, this portion was not on the originally approved site plans. That's what we do know. So I don't know if that answers your question. And again, I'm not a legal expert as it comes to our ordinance. We use the best information possible, and we believe that information was correct enough to issue a notice of violation for it, especially given the urgency of the matter that the downstream property owners were being affected at it. I don't know why Mr. Wilson and the condo association didn't file a lawsuit. He did state to me a couple times that they thought about it, but they never pursued it for one reason or another. He said that they always hoped they could work something out. And I think that, they ultimately didn't want to get caught up in a drawn out legal process in which it would take years for them to get any type of relief. They couldn't go on Mr. Chan's property or Mr. Brazel's property and do anything. They couldn't go over there and fix anything. And Mr. Wilson, Lonnie, he sent me tons of photographs of where they went to Home Depot and bought silk fence and sandbags and spent weekends trying to dam up what they could on their property. He asked me at one point if he could go over on Mr. Chan's property and just put something up over there. I said, you can't do that, again, and I asked him to attend this meeting and the last meeting. And he had an engagement on the last meeting. I talked to him before this meeting, and he just doesn't want to get involved anymore. He's a super nice guy. He is super patient. He worked with us. He was very patient with us. I think he was more than patient with Mr. Brazel and Mr. Chan. And I think he's just happy that something is finally done. So I can only share the opinion of what, I have that he told me about the experience and where they were coming from. I know there's several Christian organizations that do business out of that condo association. And I think that kind of had something. I think a lot of the tenants just didn't feel like a lawsuit was something they wanted to do. They were always hoping, he said, that that they could work something out. So again, that's as much as I think I can, and I'm inferring that, of course, through what Mr. Wilson, told me of the matters.
So, Mr. Jones, what I would add is looking at the Exhibit 1 notice of violation, what he was, the violation was parking lot construction without approved plans and permits from the city engineering department. And thank you, Jeff, for showing that. So hopefully that answers your question.
I do have a picture here, okay, that I don't know if I can share, but this picture here, if you guys can see it, was actually taken, and I have here what it shows here in this date. So January 18th, 2012. And this is what Jeff just now showed me, whatever the paving was that he was talking about. So this was already done in January 18th. My purchase of the property was actually past that. Here's this is the first thing I could pull up just now. It was on February 2012 was one of the closing dates that we were going to do. This was a counter offer for 126.12. So this is paid before I was taken over. I mean, I did not know. So I did not authorize any paving or anything done as far as this is concerned. So I don't, now that Mr. Jones here brought up this point, well, that's true. I mean, what jurisdiction do you have? Well, I don't know. I'm not a lawyer, but I will say that I did not do any construction to cause this problem. I did try to put in berms some road berms to actually try to solve the problems. I did put in sandbags, I put in rocks later on, ripraps to try to help the situation, but that's all that I've done. So everything else was done before me. So I hope that clears that up as well.
This is Michael Scott. I do have a question for staff, kind of along this lines Mr. Jones was asking. And just so I understand, because I'm a little confused on the jurisdiction. I get the NOV for unpermitted paving, but when I look at the jurisdiction that Mr. Jones cited, it does reference involving less than or more than 5,000 square feet, more than 5,000 require a permit. So is this I guess the jurisdiction or the regulations we're citing, or is there another regulation regarding paving that this is in a violation of? Or, and my second question, follow-up question is, do we know what that area of paving was, if we measured that out on Earth or anything like that?
I don't remember off the top of my head. I'll have to go back and do that. And as far as the jurisdiction, I know our codes department, Paul, you can correct me if I'm wrong, but would have required a permit as well for this. I may be misspeaking on that, but I thought, when we consulted with everyone about this, that we determined it was a stormwater and a zoning issue. So, again, we felt that we fell under the right jurisdiction. It was aggravating a flooding issue. So again, I'm not a lawyer, but my interpretation of the ordinance was that we had jurisdiction to issue a notice violation based on that.
Yeah, some of the stormwater requirements may not have applied, but he is still was still required to get appropriate permits to do the paving, and I'll agree, Mr. Chan did not do it. We're fairly confident based on what he's shown that he didn't do it, but he did buy the property. He is the current owner, and when we find these type of issues, we're not out necessarily looking everywhere for them, but when they're brought to our attention, when we're flooding downstream property owners, they do get evaluated by staff and looked at, and it is considered to be still development without a permit as it relates to us and our interpretation of it. And I hope that answers your question.
And Mr. Brazel was having to do stormwater quantity and quality improvements with his project, which Mr. Chan didn't have to do. So that's what Paul was talking about as far as that jurisdiction there.
It sounds to me that since Mr. Brazel owned my property and my property had that violation of that pavement before I bought it while he was still owning it, and now he's also being fined for his problems, or not fined actually, but he's asked to do work on his problems with the quality and quantity of the stormwater. Sounds like I shouldn't be getting this NOV. He should be the one that's getting the NOV. Isn't that part of being fair too?
Mr. Chan, you were the current property owner, so that is our protocol of who we issue notice of violations to.
Okay, does anyone else have any questions or? Seeing none, do we have a motion on the item?
Mr. Chairman, I think I'm reading the opinion email that was sent out by the city attorney on it earlier. I'd like to make a motion that we reduce the violation, that we do determine there is violation, but reduce it to the sum of $5,000 under that section. It's under 23-111, civil penalties, subsection D, subsection I, number 3 of the city ordinance. It says to violate any acts or omission, any terms, barriers, modification, condition, or qualification placed by the city or agent department upon any required permits. Because basically, if we go this is that he didn't have the permit to do this, is I would make a motion that we can either reduce it or basically show that there's a violation under that section.
So your motion then is to uphold the city engineer, but with a reduced penalty of
Yes.
$5,000? Is that where we're
Under
headed?
that section.
Amber, do you need any clarification on his?
I think I have it.
Okay, so we have a motion to uphold the penalty, but reduce the amount to $5,000. Is there a second to that motion?
I second Ann Peterson.
You have a motion and a second. Is there any more discussion on this item? Seeing none, we'll do roll call vote on the motion to uphold the city engineer's position, but to reduce the penalty to $5,000. Chairman votes aye. Tom Jones,
Aye.
Susan Besser,
Aye.
Albert Cox,
Aye.
Michael Harbauer,
Aye.
Ann Peterson,
Aye.
and Michael Scott.
Aye.
Okay, the motion passes unanimously. Okay. We have an item on the agenda for public comment. I don't know if there's any further public comment. Is there any other business before the board tonight? Seeing none, is there a motion to adjourn?
I move we adjourn. Ann Peterson.
I'll second that. Save
That's Susan.
Susan Besser.
Okay. Chairman votes aye. Tom Jones,
Aye.
Susan Besser,
Aye.
Albert Cox,
Aye.
Michael Harbauer,
Aye.
Ann Peterson,
Aye.
and Michael Scott.
Aye.
This meeting is adjourned. Thanks to all of you.
Thank you everyone for your time. Have a good night.
Thank you, Mr. Chan.
Thank you.
Good night, everyone.